wait for the microphone.
I would like to ask you one question, that you said that 25% of the parking space has to be reserved for the visitors. But is there any
Regulation 36 table 15 of the Development Control.
Fine. Is there any time limit for the visitors parking? Can the
24/7 by 365 by n number of years the building lasts.
No, if some visitor is parking his vehicle saying that I am a visitor and he is parking his vehicle for 365 days, can he do that?
See, as Bombay Municipal Corporation, they are concerned that supposing if 100 parkings are there, 25% means 75 are meant for members, 25 are meant for visitors. And for that the society has to frame rules. I mentioned that society has to frame the rules.
This is regarding for car parking deposit. If the society forcefully asks for the car parking deposit in lakhs of rupees, so what we can take as steps against that?
As an individual, you can straightway take the matter for extortion, criminal breach of trust against the managing committee members, as well as go to the consumer forum and claim compensation, deficiency of service and unfair trade practice. The problem is everyone wants not to be in the bad books of the society.
Good afternoon, Mr. Sampat. I am retired GM from State Bank of India. After that, we had a occasion of buying a flat in a newly built society. As of now, the problem, whatever is going on, that is going to elaborate here. But the fact is, what about Amendment 2013 that has been carried out in Maharashtra Cooperative Societies Act? Has it not been notified?
No, it has been notified, but see, it is all these things are piecemeal because still election-related things are not framed. So by the time in the next 3-4 months, 6 months, election things will be framed. So again, there will be amendment.
So what is the legal sanctity of the point that most of the societies have already adopted the bylaws that has been framed?
You will again have to adopt the bylaws.
We have to be
Again it will come.
Earlier one or the new one?
Again new one. It is 2013 is there. In 2014 again.
You need to have a 15 persons to be managing committee member.
You have?
You have to have minimum 15 people as a managing committee member.
That in all probability that is a blunder committed by the authorities that they are going to rectify it. These acts which are they have been putting it in paper has been done without application of proper mind because it is full of mistakes. For example, a child also knows that shares of a cooperative society we have got to register it because of the amendment of Section 53 of the Transfer of Property Act. Section 41 of the Maharashtra Cooperative Societies Act says that shares of a cooperative society need not be registered. Now the number of managing committee members are there. That is also ridiculous for this provision. They are trying to say that you should take pride that you are a scheduled caste member and seats are reserved for a scheduled caste member. If I am a scheduled caste member, would I like to show it as a matter of pride for the society? Because if I am taking my admission for my child, I will gladly mention it because I have got a personal gain there. Here I am not getting any gain. So they have presented in the wrong way and I have no hesitation in saying again there will be an amendment in the Maharashtra Cooperative Society.
What is the remedy as of now? How to go about it?
See, what happens is, remedy is just to take out your vent. Otherwise, if someone is so keen, he can go to High Court and challenge all these things. But at the end of the day, they are not practical things. Wait and watch is the best remedy. They themselves have understood the things. They themselves have understood, and I am told to one of the journalists, the minister himself has told this thing that we are looking into this thing and something will be done. Whenever you come across this type of things or these things is there, you just ask that officer. He will, silence is golden. He will not dare to give you in writing, you have 15 members, you have scheduled caste members. He won't have, because informally many things are told from top.
So for parking, if you have an old society, pre-1991 DCR, and say 82 and society from 84, and then that time for pre-1991 DCR, say 82 and 84, what is, if parking was sold by the builder society, accepted that position, what is the position in law for this old, which
in the eyes of law, but just by paying money you don't get the right to it. If even the society has recognized your parking rights, say in the year 2009, after 6 months they can always challenge that, they can pass fresh resolutions and they can take it today.
No, if it was accepted in the conveyance.
That was at that point of time. Today it's a different scenario. General body is supreme. They can overrule that.
Mr. Sampat. Mr. Sampat, I had an issue. See, this Urban Land Ceiling Act actually was taken out by the government in 2008-9 sometime. But in 2006, many of the societies were actually getting captured in this particular act when there was a collector authentication which was done on the collector name was actually got stuck on the land of that particular society. What is the remedy out there?
See, basically now the ULC Act is scrapped. About ULC, I will say it's called ulcer, and practically every chief minister has kept this department with him in Maharashtra. When a building permission is being given, they have to give declarations that they will execute the conveyance, and all these things are commonly violated. So as far as now that act itself is scrapped, if proceedings are initiated against that definitely they have got the right to continue with those proceedings. But now one cannot take shelter because that act is scrapped and you are moving something today.
Yeah. Sir, for a flat bought in Dombivli in a cooperative housing society in the year 1984 on the basis of agreement drafted on 200 rupees stamp paper, when cooperative flats were exempted from registration, what is the hurdle while selling it now with respect to registration and stamp duty payable?
See, I'll take another question from this. What has happened is, earlier, say I purchased my flat in the year 1987. Somehow I paid the stamp duty, but I did not register it. Now, this government like Mohammed Tughlaq wants us to pay stamp duty at 2014's rate if you want to register the document. If you just go to the authorities and tell them you take stamp duty from your 87 rate, they will work out, they will collect it. But if you say I want to take a registration or I want to do registration, registering officer will say nothing doing, you pay at 2014 rate. So I took the opportunity from taking it from on this question. Now specifically coming to your question, you are a member.
Yeah.
If you are selling this flat, the new purchaser will say, I am paying a 100 rupees thing, I am paying you 100 rupees for a 100 rupees thing. Why should I take this trouble? Why should I have a defective title? So this is leading to an number of problems, and ultimately the government should take a practical, pragmatic decision, which sadly it is not taking. So ultimately all are suffering. And here I may also add that bankers also, my experience is not that good. They very conveniently overlook wrong things which are omnipotent, and though they know it is wrong, they allow. For example, I was mentioning Maharashtra Ownership Flats Act Explanatory Note 2, which clearly stipulates that all the earlier chain of agreements should be made a conforming party. Bankers know that if they insist for such clause, they will not get business, because legally it may be right, but ultimately no developer would like to go to his predecessor. Otherwise, at every flat registration that he will demand his pound of flesh. So they very conveniently overlook such things.
Okay, the last row, please.
Hello. So you just said that if there is an unauthorized construction, one can write to BMC under these acts. So BMC takes its own time and doesn't act. That's obvious because of the reasons. The member does it. And what does the managing committee has the way to penalize that particular member?
Managing committee can also take up the action within the cooperative code if it wants.
But then, see, suppose if he does the construction today, by the time the managing committee goes to the court and gets the things done, it will be years, So if he does the unauthorized construction and goes on for years together, then
that's why the law is called an ass.
It's not a question, it's a general one. Now these registrars, deputy registrar and assistant registrar, there is no accountability. They can pass any order. Wrong, right, anything, And there is no accountability. It's you can go high up for the appeal.
In fact, we have written many times to the concerned cooperative department that under the provisions of the Right to Information Act, you are duty bound to upload all the orders on your website. But you will rarely find any order of the cooperative department being uploaded.
Okay, next question here, sir.
Thank you, Mr. Sampat. I have one question pertaining to our society. Our society had gone for partial redevelopment in 2003. Now, in lieu of redevelopment rights, the builder was supposed to give 2 residential flats and commercial premises to the society as its consideration. What he did was he raised a host of illegal demands, and since 2006, he has kept those 2 premises and the commercial locked. So society does not have physical possession, nor does it have a title to that. Now we have received BMC property tax bills from 2010 onwards, and the bills have ballooned to 19 lakhs. Society's stand is that because the builder has kept it illegally locked, he should be paying the property tax. Now, is it society's responsibility to pay, or is it for the builder to pay? We have gone into litigation.
Number one thing, why the first thing is, instead of going for a solution in terms of leaves and branches, cut the root, file straightway criminal action against the builder for cheating, criminal breach of trust. As a revenue generating authority, it has got it makes no difference to it whether BMC, whether you pay or the builder pay.
That's correct.
The correct way will be for you to pay the amount under protest and initiate action against the builder. If your society does not want the benefits of that thing, then you should be prepared to suffer. You should force upon your committee to take action, and the best way of taking action is you take action against your committee. In consumer court, that members of the managing committee are jointly and severally liable for their acts of omission and commission, and this is an act of omission as well as an act of commission.
Okay, thank you, sir.
I have a question on redevelopment. The buildings which are constructed in 1970s, 80s, as per the approved plan that time, their areas have got changed. In the sense, some people have extended balconies and all that. So recently, when our PMC appointed gave us the feasible plan, he gave flats of different sizes, though all are equal of say 2 BHK. He gave of different sizes. Ideally, it should be 650 square feet, but PMC gave of different sizes, right from 600 to 800 square feet. Some people challenged that, some people gone to municipality to get the original plan, what it was, where the flats were shown equal. Now there is a fight going on, and we don't know how to resolve this, because some people say we want more, some people
So
say
what's
we
your
not
question?
My question is what is the legal way out of this? Who is eligible for what?
Humorously speaking, we sometimes call PMC means Pura Malai Kamalo. This was of course said just to introduce a sense of humor. Basically, see, it is your society. In your society, what majority of the members wants is important. So the general body resolution will prevail. Second thing, on this point, I would like to educate the readers how BMC is minting money and misguiding. If the properties of layouts were concerned, 1.33 FSI was granted. Against 1.33 FSI, now BMC is saying that only 1 FSI, because for a building to be constructed, you have to first get the CC, commencement certificate. That requires the entire building first to be demolished. And BMC said that though your 1.33 FSI is used, we will give you credit only for 1, and for 0.33 you will have to pay the stamp duty ready reckoner rate. This is how BMC is literally extorting money from the flat purchasers, the members. I told, as far as they are concerned, the general body resolution will prevail. General body. See, what happens is, you purchase the flat. There was some FSI available to you. Now, according to you, because you are using this premises, you are entitled to that premises plus certain percentage uniformly to be agreed. Some members of the society say, no, we are not comfortable with this thing. So in such a scenario, what is the resolution that is passed by your society at its general body meeting will prevail. And if you feel that resolution is not correct, then you have to challenge that resolution in the court of competent jurisdiction. But by and large, in society matters, the resolution passed by the society at its general body will be the basis on which the things will proceed. So that is what I am trying to tell you, that you challenge that. Supposing you are in minority, you challenge that resolution and court will hear your matter in depth.
One question about transfer of flats. If a member dies and there is a nominee and the flat is transferred in the name of the nominee, if for 1 year there is no other contesting claim, does it give a right to the nominee to transfer that?
See, even today, if member A expires, B is the nominee. Statewide society has got nothing to do who the legal heirs of A are. Society just endorses on the share certificate the name of B. Membership of a cooperative society and ownership of the flat are entirely two different aspects. If A has made B the nominee and C, D, E are the legal heirs, flat is obviously transferred in the name of the nominee B. Now CDE being legal should be vigilant. If at all B tomorrow creates further title on the property, which many say that the nominee does not have a right to transfer the flat. But in my view, nominee may do it, but the purchaser is taking it at a very, very big risk, because nominee is merely a trustee of the property. He does not get any ownership right in the property, and membership of a cooperative society and ownership of the flat are entirely two different concepts which are normally intermingled. People think that the nominee is the owner. It need not be so.
Yeah, I just had one question basically. Okay, I wanted to ask that in case, according to the BMC records, if the carpet area has been calculated more than what it was actually be. Actually, the carpet area has been calculated more in their records. And
I am not getting, please elaborate.
in the BMC records, the carpet area has been recorded as more than what it was actually, because of which the property tax also has been calculated more. Now all these years, if I have been paying particular say property tax, and when it is discovered that actually it was not supposed to be like that, is there any recourse, and can I go back to the BMC authorities and say, and they have come and inspected and found that it was their mistake? So is there any recourse? Can I
The Bombay Municipal Corporation Act clearly stipulates that whatever your property tax bills or any appeals have to be filed, it has to be filed in the month of December for the last year only. So you cannot get money for the legitimate amount paid by you for the earlier years. Only the last year's money you can claim it. But let me tell you, on these are humorous and factual things. Your case is that you are having less area and paying more tax. But the ground reality today is the builders are allotting you 1,000 square feet flat. In reality, in BMC, it is a 600 square feet flat and 400 passage area is there. That they give it to you, take money from you for 1,000, and I am talking of top builders. Top builders have done this thing. Passage area has been included in the flat, and then they are telling the flat society's members, you want me to fight, you want to fight with me, I will tell the BMC that your area is less. This is what is happening.
I have a question on the associate membership. The definition in bylaws and circulars is confusing. They say that an associate member is a person whose name does not stand first in the share certificate and all that. But is it necessary that associate member has to be a joint owner, and can anybody be the associate member?
See, number one, bylaws do not have the force of law. Supreme Court is very clear. Andhra Pradesh Industrial Tribunal judgment is on that. Now, Rajput versus Rajput High Court case has created a problem whereby associate members, everything is defined, and in my view, he has got absolute right in the property. If supposing if a father is there, father expires and there are two brothers, if both the brothers' names are included, definitely the second brother will also have a right. But now what has happened is the new housing manual stipulates that only society is concerned with the first person whose name is there, and definitely in my view it is a blunderous thing. Just administrative convenience is seen. What has been the implications of the department is one flat is there, one general body is held, and one member can only attend. Multiple people should not be allowed to attend. So what they say, only we are concerned with the first member. This is leading to a situation whereby the second person may have rights in the property, but he is not having this. Here you should understand that Cooperative Society Act is a very small act. It is applicable only to Maharashtra Cooperative Societies Act. Whereas we have got various central acts like the Transfer of Property Act, Income Tax Act, and all of them recognize the right of Transfer of Property Act, which recognize the right of co-ownership of a property. So in my view, definitely the rights of the other co-owners are bound to be protected. But as far as interaction with the society is concerned, because of the amendments in this housing manual being inserted, he may not be able to attend the meeting of the society. If there is peace in the family, the best way will be to have an agreement drafted and show that 1%, 2% share in the property is purchased by the second person. So at least on paper, there is a record, a gift deed is made whereby brother says that I am giving you 1% or 50%, whatever is there. Have it registered document that will protect your interest, and you will have foolproof peace permanently.
Otherwise, it may create a confusion that there is a ownership also.
Yeah, because tomorrow, legally you may be correct, but tomorrow, practically when you look at ladies and all these things, people feel that my whole flat has been grabbed by the other party. So that psychological effect is more.
Yeah, see, my name is Amit. I have a question on the conveyance of land. Now, we have a condominium in Pune, and when I inquired to office bearers about the land conveyance, what they are telling me is that dates of declaration is equivalent to the land conveyance.
Absolutely correct.
This is correct?
Absolutely correct. What you have to say here is that declaration should contain the percentage interest of each of the co-owners.
And we do not have to go for the unified, that is unilateral deemed conveyance.
Absolutely.
And it is only applicable to the cooperative housing.
Absolutely correct.
That is correct. Okay. Second question is one.
Time, please.
Short. There are three options. One is cooperative housing society, then the condominium and the companies act. Under three, which is the best option to form the thing?
That will depend on the taste of the person. If I am a builder, I am selling the property to one builder. I have one private limited company, 50 properties. Then I will advise him to go under Companies Act. But if it is an individual who is purchasing, then cooperative society is better. I think, Sucheta, you should put a condition that if you want to ask for a second thing, you will have to take one compulsory subscription of Moneylife.
I should think so, That's the least they should do because they're getting your valuable advice free.
Sir, if you can please elaborate on transfer of flats allotted under MADA. If you can enlighten us on that.
Means what do you want? Already flat is allotted.
Can we sell that flat?
Pardon?
Can we sell the flat?
Why not? No, the restrictions are removed.
There are some restrictions are there, sir.
The restriction, in that is, in MADA still it is there. But other thing of subletting has been removed. MADA subletting is removed. Selling is, that restriction is still there.
Thank you. A lot of residential building has particularly ground floor and first floor being used for commercial purpose. I'm not talking professional using it for self thing, but the, gyms or other music classes and this kind of thing. I was a secretary of that society. I wrote to BMC and even...
So what's the question?
The question is how, after writing to BMC is not taking any...
Development control use permits such uses, ancillary uses. It is permitted.
I'm talking, a lot of publics are coming in.
No, see what happens if you look at development control regulations, in a residential you look at many banks. Why are you allowing banks?
But that requires the permission of the society. Without
No, they won't normally go for permission. You as a cooperative society should oppose it. You as a cooperative society should be vigilant. You don't wait for that bank to come up and then you say this is that. You straightway take an injunction in the advance only. And you put some way pressure tactics on them so that they won't dare to come.
This society has issued 5 qualification shares to each members. Then subsequently when the loan from housing society was to be taken, the additional shares are also issued by the society. But for that no money was actually paid by the members, but only a book entry was passed from the contribution from for the construction amount. So now the loan is repaid. Entire loan is repaid by after 20 years. But now the society wants to reduce the debt capital by making again reverse entry only by book entry.
See, number one, I fail to understand how you are saying that entry is there in the books but money is not included. What cooperative societies do is they issue loan stock bonds and the loan which is being taken from the bank, at that time certain component is taken there and it may be adjusted against your pro rata amount. You as a member feel that my loan is taken of 5 lakhs rupees, but it may be of 4,95,000 and 10,000 may be taken towards loan stock bonds. That way it will be. You check up because accountant will not allow such things to come in books unless there is some monetary transaction. It may be in the nature of journal entry.
Yeah. Hello sir. Our Chawl has been developed to a new building and the occupation certificate was promised in the 6 months, but after 3 years it was not been given by the builder and the society is also not been formed yet. Now our water connection is being disconnected by the BMC and we are not having any water. So what is the remedy for this? Now how to get water connection? Builder says he has no money, he will not pay to the BMC to
See, first and foremost, BMC has got certain norms. You comply with the norms, they will give you water connection. If your builder by all means has not complied with that norms, why should BMC give you that connection? So your remedy is against the builder. You are a consumer, you take him to consumer forum as well as to the criminal courts. Then automatically things will start moving. What he has done is he promised you the premises, he took some FSI, constructed a building, sold it to some new flat purchasers. And he is now just ignoring you. So you have to take action against the builder.
So we have to go to the consumer court or what, where? Where we have to
He
go?
said consumer court, or you can file a criminal complaint. A consumer court. So
My
you-
name is Rajesh Hinduja. Yeah, if the society wants to go for deemed conveyance, is registration of each flat necessary for that?
In my view, deemed conveyance is as good as dead conveyance. I don't advise a single person to go for deemed conveyance. It is full of loopholes, full of blunders, and in spite of spending huge amounts as speed money, you will not get a proper title because you will not get the building completion certificate. You will not get the original documents of title to the property. The property card will not be conveyed. All these things you can get it in a better manner from the consumer forums. I will strongly urge you, don't fall into the trap of deemed conveyance. It is the authorities who are trying to favor the builders indirectly, and sweet talk from an election point of view is being done for deemed conveyance. Actually, they don't want to help the flat purchasers. All if the government is so serious, they want to help the builders. If they want to help the flat purchasers, what stopped the Maharashtra government authorities from 1963 when MOFA came to make the offences against builder non-bailable? If they just introduce 3 simple amendments, non-bailable offence, then 10% of the premises to be sold only after getting the building completion certificate and handing over original documents of title to the property, there was no need to talk about this conveyance. The only qualification for a builder is sweet tongue, smiling face, and practically every political party is having builders at the helm of the affairs, so they are ensuring that conveyance finally does not reach the end user. Only lip sympathy is being given.
My society for deemed conveyance, so they are pressurizing the flat owners to give double maintenance if they are not registered flat.
No, that's a wrong thing. Totally wrong.
Yeah, one question. In your presentation, you mentioned about leasehold property and freehold. So if there is a now MHADA is also giving lease and it is only a 30-year lease is there. So if the 30-year lease is given, then can the society go for redevelopment, and if yes, what happens if the
At
lease
the
period
discretion of MHADA.
At the discretion
You have a limited right.
Okay. Thank you.
When the society is registered, the bylaws are also registered with the registrar. Now those bylaws are subject to amendments and over
Sir,
a
will you hold the
period.
mic closer? We are recording it. Yeah.
Over a period, there are certain changes in the enactment, and lot of amendments come in the law also. Now, what is the rule? Those amendments are applicable directly without amendments to the bylaws, or unless they are amended in the general body, they don't become applicable.
The procedure for any amendment is, first there has to be a general body meeting. Once it is passed at the general body, proposal is sent to the registrar. If registrar finds that that bylaw is within the framework of law and it is not opposed to public policy, then he will grant permission, and thereafter only the amendment will come into effect. So automatically, until and unless it is approved by the general body, it cannot go to the bylaws.
It has to be adopted.
Yeah.
Question behind.
I would like to ask you a question on the mobile towers point that you have mentioned, that there are a lot of illegal mobile towers. Now, if the housing society installs tower IT and there's just one person opposite the towers and rest all the societies are agreeable to the towers, ignoring the health hazards and everything, is there a way out a single tenant could stand against this?
High Court has given a stay for the BMC to take action. You as a cooperative society you can definitely have got a right. You can terminate the agreement and proceed.
As a single?
Yeah, see, in your society there is a tower. That means that the tower company, mobile tower company was hand in glove with your earlier office where some agreement was executed. You terminate the agreement. if there are valid grounds for termination, like not obtaining municipal permission, etc.
Thank you.
Sir, is it very rates are the reliable source? Having a different facilities in different societies, this question is in the consequences of the property tax also.
See, I have repeatedly stated that in writ petition number 550 of 1994, government has given an undertaking in contempt petition in the case of Mutha versus State of Maharashtra that government will not use the ready reckoner. But there is not a single instance where government is not using the ready reckoner for stamp duty purpose. Basically, ready reckoner is a guideline, but they have made it a gospel truth. Similarly, carpet area, built-up area, the authorities feel that you have to add 20% area to built-up area to make it carpet. That is not correct. It is just a fertile piece of mind. Any architect will tell you that the ratio of carpet area to built-up area can vary from builder to builder and from project to project.
Yes, ma'am.
Yeah, it took me some time to make eye contact with Suchita. My question is, you said the committee members are soft targets for most of the thing.
Yes.
In bigger societies, there is almost a race to come into the managing committee. Whereas in smaller societies, there's a great reluctance to become a committee member.
Absolutely
so
correct.
What do you advise? How do you persuade?
There is no option.
I know that.
If there is an option, I can advise you.
We are all retired, still nobody wants to.
Sir, A and B having identical flats in the same society, if they decide to exchange flats, any stamp duty or registration?
Only once it will have to be paid. But the question is, you cannot tear an agreement. Supposing on your agreement you have paid 1 lakh rupees stamp duty. Who is going to keep that agreement? And tomorrow, 5, 10 years, 20 years down the line, when you sell that flat, who is going to retain the original agreement is also a question which you will have to sort out amongst yourself.
But any agreement to be signed in this regard, or is it just sufficient for them to agree to do that?
Pardon?
Is there need to put the agreement in the writing and then register it, or is it?
No, registration is compulsory. My reply to you is, there is flat number 501, there is flat number 601.
Yes.
Only one stamp duty is paid. That is the law of the land.
Yes.
After paying stamp duty, after registering the document, you can take official copies of 100 rupees stamp paper as many as you want. But on the 1 lakh rupees stamp duty, supposing is payable in your case, which you have paid, you are not going to pay it twice. You are going to pay it once only. So for that thing, who is going to keep? 10 years, 20 years down the line, when again the flat is sold, both of them would like to have it for themselves.
No, both of them have already purchased the flat separately, and now they want to exchange.
So that is what I am saying. You will have to pay stamp duty once.
Yeah, okay.
So you pay it once.
Yes.
Who is going to keep, A or B? Original document.
But A and B individually have their own respective agreements with the builder.
Either it will take long time for me to explain, but the crux of the thing is, law is very clear, only once on exchange has to be paid. But if you look at a point of time after 20 years from today, who will keep that original agreement on which the stamp duty is paid today? That is a problem.
Good evening, Mr. Sampat. For a group of tenants who are not registered under Cooperative Societies Act, but just a flat occupiers association, welfare association under Charity Commissioner's office, what is the protection for entering into a redevelopment project?
Tenants Association, Welfare Association, in my view, has got no legal entity. They have to just plead with the landlord, pay some money to him, become owners. Otherwise, the individual tenancies or anything, you are literally your position like a girl's father. Right. Go and get your things done.
Because our building position like Draupadi, we have so many husbands. Thank you.
In my case, the external repair is to be done by the society, like lift room, water tanks and all that.
Yes, speak louder, please.
Yeah. You see that repair is to be done by the society for overhead water tanks, lift rooms and etc. But they are saying go to the, mine is the multiple buildings in a society. But they are saying go to the working committee of that building. and there is practically no working committee in the building, and the society says we don't have any responsibility, go to them only. So what is the solution as a flat owner in that society?
We taking up the issue in consumer court. I told you the best remedy for an individual who is aggrieved is to take action against the society in consumer court. You can also lodge, supposing there are 4 flats on the top floor, and 4 of you are together. One takes up the matter in consumer court, other takes up in police, third takes up in BMC, fourth takes up in cooperative court and registrar. Like that you spread it, so the pressure will come from all the 4 sides.
Okay. You see, they are saying
your action will be against the society. It is not the building based. Building based committee is just an ad hoc arrangement by the main parent society. You are paying account pay check in the name of the legal cooperative housing society. So your remedy is against them.
Okay. But they are not giving anything in writing. Only verbally they are telling go to the...
The court summons will may force them to give it in writing.
Any other questions?
What is the remedy available to a lady who is a legal heir and her name is not there on the share certificate, but she is bequeathed some portion of the property by her mother?
She should get the will probated.
That is the only remedy.
Yeah, because how do you know or anyone knows whether this will is genuine or bogus?
But society will not come into the picture.
But I'm asking you a simple thing. Every 100 people will say this is my mill. I'm the owner of this. So it should have a stamp of the court.
Yeah, I have, during elections, the committee just names the appointees, and they have show of hands and appoint the
What's the question?
Committee. So is that legal? I'm saying
Section 92, one of the Maharashtra Cooperative Societies Act stipulates that election dispute should be sorted out or should be challenged within 2 months. Obviously, the time period has gone now.
No, I'm sorry. In the AGM, when you
a show of hands is okay, right? Unless challenged.
No, there has to be a ballot depending on this thing. But the question is now elections cannot be held, and your question pertains to a period which has occurred some time ago. Right now, we cannot hold elections because of the new amendments in the Maharashtra Cooperative Societies Act. Earlier, when the election was conducted, within 2 months only you had the time to challenge the thing. As far as the elections conducted by show of hands or by polls, society has to conduct by ballot if the share capital exceeds some 10,000 rupees.
Can you elaborate regarding the service tax you mentioned that the society has to pay? Isn't there so many court judge? It says that on mutuality basis, there is no service rendered by one to oneself. So is it applicable, service tax?
See, mutuality is a good ground. 5,000 rupees, no issues. Property tax, no issues. Water charges, no issues. But by and large, this thing does not appear as simple as it is. We feel that we are paying normally 4,000 rupees, so we are not covered under service tax. But if you look at in between the lines, you are caught. Why I say in between the lines you are caught? In your society, normally 2-3 transfers must be taken in a year. So every transfer you charge minimum 25,000. 25,000 plus your maintenance when you include, by all means it will cross 60,000. So there you will get caught. That requires to be tested because mutuality aspect is definitely a plus point for the taxpayers, but it is like this thing, department has made up its mind, department is saying you have to pay. If you feel that, you get an order from the court. If the mutuality aspect was so good, then there was no need for this amendment on their part.
Sir, service charge is being levied equally as per the model laws, and the water charge is based on the usage. In several societies, this is not being implemented in spite of acceptance of the model bylaws. So is it legitimate or not? And what should be the correct perspective when there is nowadays variety of areas available in the ratio of 1:10, in the same society?
See, I told you, professionals are always soft targets. So you give it a different flavor. You write one letter to the auditor, why I should not take action against you for professional misconduct. He is supposed to comment on the accounts. Service tax, Vinod Society's judgment is very clear. It has to be equal. You write to the registrar, that society is not taking this thing, and you tell the society that for the last 10 years you have collected this way, so you please amend your books of accounts for the last 10 years and send me this thing, and put this payer in consumer court, that they be directed to amend their accounts for the last 5 years and call that auditor to task in the Institute of Chartered Accountants of India for professional misconduct.
Okay, with that, all good things have to come to an end. If Mr. Sampat is going to take some questions after the session, Moneylife likes to end our sessions in time.